Hi everyone, my name is Shazia Khan. The unit we'll be doing today is Unit 7, which is Business Law. Are you all on the right one on Business Law, yeah?
Yeah.
Yeah,
Yes.
excellent, thank you. And the learning outcome is today we'll be doing, so there's 4 learning outcomes. And the one we'll be doing today, so there'll be 4 learning outcomes, and then there will be, let me just have a look quickly. There'll be an assignment discussion, okay, towards the end. And we've got a session today, and then we've got a session tomorrow on learning outcome 2. So today we're looking at learning outcome 1, which is looking at explaining the nature of the legal system. So the indicative content today is to look at defining what the legal system is, looking at the purpose of the law, why law is so important, the evolution of law and different sources of law, example, legislation, directives, case law and treaties relevant to the country. And divisions and key terminology of legal system, for example, court structures. We're going to look at the difference between criminal and civil law, and we're going to look at the justice system and the role of government in making the law, and also the justice system and the organisation of the judiciary. So when we talk about the purpose of law, what comes to mind? What do you think the first thing that comes to mind? What is the purpose of law?
Basically a framework from which society operates.
A framework from which society operates. Excellent. Anything else? People have different perceptions. Okay, so I could say that when we talk about defining what law is, I could say that it's rules, you know, that we must follow. Anything else?
Orders.
Sorry?
Maintaining orders, establishing standards.
Excellent. Maintaining orders, yes. Establishing, you know, following rules, following regulations. So everyone's got a different definition, and everyone has the different purpose of law, but it all comes in as one thing, which is to maintain any sort of order in the country, but also follow the rules and regulations. So what is the legal system in the UK? So the UK legal system is a set of institutions. So we have Parliament, legislative, judiciary, executive. We have rules in place and procedures that govern the administration of justice. It ensures that disputes are resolved, laws are enforced, and individuals are protected. So in a country where there's laws based on the fact that you can't drive a phone whilst on your mobile phone, sorry, you can't drive whilst on your mobile phone, must there be a law in place to say that? Do you think there's a law that says that you can't drive and use your mobile phone at the same time?
Not directly, but I think there would be a law regarding the rules to drive on a road.
No,
I don't think.
Yeah, I think there is a law in the UK. It may sound different, you know, different countries have different laws, different jurisdiction, but in the UK, there is a law that identifies that if you drive your phone, sorry, if you drive your car with a mobile phone, you will get £300 fine and 6 points or something. So there is a law in place that identifies that. So, you know, we have different laws in different countries because, you know, each country has its own jurisdiction. The laws in India may be different to the laws in the UK. You know, the laws in Pakistan or Kenya may be different to the laws in India. Why does every country have its own law? Does it have a different legal system?
Yeah, different countries have different legal system.
Yeah.
Not exactly the same laws.
Yes. But the law, the whole point, the purpose is to maintain any sort of, you know, maintain an area of law that is enforced, but also that the country is protected. That's why laws are in place. Are laws followed all the time?
No.
No, why?
Because some people don't wish to work in that sort of rules.
Some people don't wish to follow the law. Okay, some people, are quite stringent on the law, and others, don't want to follow it. So some rules are broken and laws are broken. So when we talk about the purpose of law, laws are rules that regulate conduct and behavior within society. So what does it mean by behavior and your conduct? Sorry, I'm full of cold today as well. What does it mean that it regulates your behavior?
Basically, it doesn't affect another citizen of the country, kind of like that.
Okay, but when it regulates your behavior, what is it trying to say? What you can and can't do?
Yeah.
Yeah. And why is that so important within society?
So that it doesn't affect other people in a bad way.
Yeah, so it doesn't affect the country, but it doesn't affect the people as well. They apply to all citizens, are enforceable by the governmental authority, and with penalties in place for people who contravene the law. So what kind of penalties do they have in place for people that breach the law?
Fines or
Yeah,
imprisonment.
yeah, yeah.
It can
Custodial
pay.
sentence, a
Yeah,
custodial sentence, or fines, or in some countries you have the tag,
yeah,
electronic tag, what you have to wear. So there's different sentences in different countries. Law has been defined as a body of rules of action or conduct by a controlling authority and have binding legal force that which must be obeyed and followed by all citizens, subject to sanctions or legal consequence in a law. So people identify that if you break a law, there is a sanction in place and there are legal consequences. So you could go to prison, you could get a fine. It depends on the severity of the crime that you commit. Do you think, and that's Ishika, do you think it's good to have different sentences for different crimes?
No.
So if you commit, let me just give you an example. If you steal a packet of crisps from a shop, okay, that's a crime, okay, and then you murder someone, should it be based on your crime that you've committed, your sentence? Which is the most severe? You taking a packet of crisps or a chocolate bar, or you murdering someone?
Murdering someone?
Yeah. So should the sentence be based on your crime?
Yeah.
Yes. So whatever crime you commit, identifying the severity of that crime, that's how they have sentencing guidelines they must follow, and they must give you this sentence that is opposed in the guidelines. So according to ENL legal laws help ensure that victims of crime receive justice and the criminals receive the relevant penalty for their wrongdoing, and an end goal of rehabilitation and the prevention of reoffending. And ENL legal states that many people believe that a society without laws would be a society in a state of chaos. So if there's no laws in place, what do you think would happen to society? Do you think everything would be all over the place? What do you think, anyone? Nandish, what do you think? If we had no laws in place, do you think everything would be everywhere? Hello, can you hear me? Yeah, no? Oh, Ishika,
Society would be.
can you hear me, Ishika?
Yeah.
Yeah. What would happen with society?
Society would be a chaotic and people would be able to do whatever they wanted.
Yeah, yes, good, excellent. Yeah, so people would want to do everything. So you need law in place, don't you, to keep a strict, thingy on what people are doing, to ensure that, they don't do anything wrong. The ENL legal states that without clear authority, figures and punishments in place to deter people from, for example, stealing, larceny would ensue. Any person could walk into a house and take your belongings with no consequences. Someone could take another individual's life without anything happening. So the laws that are in place are there to protect individuals. The evolution of law. So how it was developed. English law has an evolving history dating back from the local customs of the Anglo-Saxon, and it traces back to which survived until 1925. After the Norman conquest, they grew up side by side with the Saxon shire courts, the feudal courts of the barons, and the church courts. From the King's Council developed the royal courts, presided over by professional judges, which gradually absorbed the jurisdiction, which was the legal powers of the baronial and the exarchatial courts, which is the church courts. By 1250, the royal judges had amalgamated the various local customs into the system of common law, that is, law common to the whole country. A second system known as equity developed the Court of Chancery, in which the Lord Chancellor considered petitions. And then by the 17th and 18th centuries, common law absorbed the law merchant, the International Code of Mercantile Customs. During the 19th century, virtually the whole of English law was reformed by legislation. The number of offences were punishable by death, for example, was greatly reduced. Sources of law. So in the UK, when for centuries, the UK has been run by something which is called the sources of law. The UK has a very rich legal system that has evolved over centuries and has been sources of law that shape its legal system. Laws can be defined as the rules that govern the behavior of a human being within a civilized society. Unlike scientific laws, which are discerned from observation of the material universe and immutable, legal laws are decided and declared by human beings and may be changed by human intervention. This is true whether the justification of law is religious, philosophical, or political. Sources of law may be described as both primary or secondary sources. And, the fact that human beings are able to change laws, judges, maybe why would there be a need to change the law? Oh, then
Because
you're back now, aren't you?
change.
Why do you think there would be a need to change the law?
Because the circumstances change.
Because consequences have changed and there's a need to have new laws in place. For example, during when there was issues of terrorism in the UK had to be, because we've got an unwritten constitution, we're able to change the law quite quickly, and we could adapt or amend the law. Whereas in other countries like America, if they've got a written constitution, it could take years to change the law. So primary sources, these are legislation, which are acts of parliament or statutes, statutory instrument, orders in council, etc. And then another primary source is case law, which is decisions of higher courts or courts record, which are binding on and must be followed and applied by the less senior courts. So from the higher courts, the decision must be followed to the less senior courts. Then we've got secondary sources of law, which are textbooks and commentaries by legal writers, the opinions of legal experts, and decisions of the courts of whatever seniority, all of which are treated as persuasive and may be taken into account by a court when making a decision through the court is not bound to do so. Why is it important to follow old case law?
It sort of acts as a reference to the previous result of the situation, or you can say.
Yes, it helps them, doesn't it? It helps judges make the decision. The fact that, something, it may be that the case is very similar to an old case,
Yeah.
So the judges can rely on that. So then we have treaties as well, which are another source, and treaties are agreements between nations. They can be bilateral between two nations or multilateral among several nations. And you know, you've got different treaties within the EU, but we no longer are part of the EU. So we don't, we do still follow some treaties, but normally, you know, we don't really have the power now to follow some treaties. And then we've got directives as well. And these are something that serves to direct, guide, and impel towards an action or a goal. And so the directive from is an official notice that comes from an authority. So there's divisions of the legal system. So there's different divisions of the legal system, and it's the court system in England and Wales, and it can be considered as 5 levels. Why is it good to have different divisions of the legal system?
So basically, a regional issue can be solved, or a small case can be solved in that particular region or that particular level of issue.
And do you think it's really important that we have different courts in place?
Yeah, I think so.
Why? Why do
To
you think it's
minimize
so
the pressure
important?
on, to minimize the pressure or prevent corruption of one body.
Yes. So, you know, you could be there and you could illustrate that, you know, this court, the High Court will deal with this, and the, you know, the lower court will deal with this part of it. So it's really, really important you're able to identify what each court does and why it's there, why there's a need for that. So we have 5 levels, and they are similar to the court system in Northern Ireland, similar to the court system in Northern Ireland, and a different court system in the Scotland. And we have the Supreme Court, which is formerly the House of Lords, and the Judicial Committee of the Privy Council. We have the Court of Appeal. We have the High Court, the Crown Court, and county courts, and magistrates' court and tribunal services. Now, what do you think is dealt with in the tribunal system?
Could be the regional cases as well.
Yeah, it could be things like, you know, employment tribunals. It could be things like, you know, the fact that we have tribunals that deal with you know, discrimination, tribunals that deal with immigration. So we have different tribunals in place, and they're there to help and support us. Just 1 minute. So this is just go back to that. So this is just a diagram to identify each court. So you've got the Supreme Court at the top, which is the highest court and the final court of appeal that deals with criminal cases, and it's the final court of appeal, so the top court. Then you've got the Court of Appeal, which deals solely with appeals. Okay, it is divided into 2 divisions. So you've got the High Court, which is there, which deals with more complex civil and family cases at first instance, and it contains 3 divisions within the High Court. You've got the Queen's Bench division, which is there, which is the administrative court and deals with contract, tort, commercial, admiralty court. Then you've got the family division in the middle, which deals with all the family matters, and then the chancery division on the side, which deals with equity and trust, contentious probate, tax partnerships, bankruptcy and companies court, and patents. And then you've got the divisional court. Then below the Queen's Bench division is the Crown Court, and that deals with more serious criminal cases and appeals that have been given from the Magistrates' Court. The other side, you've got the county courts, which deal with majority of civil litigation subject to the nature. And then below the Crown Court, you've got the Magistrates' Court that deal with trial summary offences, committals to the Crown Court, any sort of family proceedings, any youth courts, and they deal with the less severe. Magistrate Court handles about 95% of all criminal cases. And then you've got the tribunals on the side, which here appeals from decisions on immigration, social security, child support. So if your benefits or anything like that, and these are dealt with by the tribunal. So the different types of tribunals that are in place, you know, that they have the fact that, you know, each court deals with something different. And it's so important that each court deals with something different because it identifies that, you know, what area of law they deal with. And you've got then the similar court structure in Northern Ireland, and the Scottish judicial system contains 4 levels: the Court of Session, the Sheriff Appeal Court, Sheriff Court, and the Justice Appeal Court. So we've gone through the UK, so you've got more of an idea what they deal with. And then the issue around the other countries is a little bit more different. Why do you think it's important? I think that's the wrong slide. Why do you think it's so important to have a different court system in place, court structure in place for different crimes? And why do you think it's so important to have the hierarchy in the courts?
Basically, it is more efficient, I guess, in terms of the infrastructure required for that particular trial.
Yeah. Because you can't have one court dealing with everything, can you?
Yeah.
It will all look at the issue of caseload, you know, that there'll be so much caseload for one court to deal with. And, you know, you need to identify that each court has different, you know, areas of law that they deal with. For example, you know, the magistrates court will deal with 95% of criminal cases, from like having no car insurance, you know, petty theft. And then if they feel like they can't deal with the cases, then the cases will be referred to the Crown Court. You know, if the case is more severe, they will then be referred to the Crown Court. And then, you know, they will deal with it by trial and have a jury in place. The difference between civil and criminal law. So a good way to remember the key differences when considering criminal and civil law is the summation from William Gerlda in An Introduction to English Law, and he identified it as the difference between civil and criminal law turns on the difference between 2 different objects which law seeks to pursue: redress or punishment. In other words, criminal law seeks to punish for an offence, and civil law seeks to achieve a remedy. For example, compensation for the injured party. So before we go on to identify what civil and criminal law is, can someone give me an example of a crime that may have been committed in civil law?
Potentially, I think so. White collar crimes are
Okay.
considered more civil law,
Yeah.
and criminal crimes may include murder or
Yeah, murder
that
or
sort of.
manslaughter or
Yeah.
you know, GBH, anything like that could be considered criminal. So civil law is quite different from criminal law. It's concerned with the rights and property of individual people or organizations, which may not always be protected by criminal laws. Civil law disputes between individuals and organizations, and it is often involves compensation being awarded. No one in civil law is sent to prison in a civil case, but they may be left out of pocket if they're found liable for compensation. Sometimes civil cases can be you taking your organization to court against something. And sometimes, you know, the organization or the business may be left out of pocket because they don't have any money, because they've had to pay out so much compensation. So, you know, civil law seeks to protect, you know, the individual as well, if they want to, you know, sue the organization. Examples of civil law cases. So we've got family disputes such as divorce, dissolution of civil partnerships, children's issues and childcare arrangements, personal injury cases such as road traffic accidents, medical and clinical negligence, and slips, trips, and falls. Breach of contract law or promise, such as cases where money is unpaid or a contract isn't honoured. Employment law, for example, when employee suffers discrimination. So discrimination can be based on their age, their gender, their colour of their skin. So these could be forms of discrimination. Civil law cases often hinge on establishing whether or not the accused person or organisation, legally known as the defendant, had a duty of care towards the claimant. For example, an employer has a duty of care towards their employees. If an employee is injured at work, a personal injury solicitor must be able to prove that the employer breached their duty of care and that this breach caused the injury to the claimant. Now we go on to identifying what criminal law is, and there's a big difference between both. Criminal law essentially relates to offences and breaches that negatively affect society as a whole, rather than just one person. This area of law outlines what Acts of Parliament deem to be acceptable and unacceptable conduct in the UK. There are also offences which can be committed by a British citizen abroad, but then prosecuted in the British law in England and Wales. For example, if someone commits a murder in India, Pakistan, wherever, they will be tried in the UK, okay? Because that's how the law works, because they are UK citizen. If a person breaches criminal law, they're subject to criminal prosecution by the state. Criminal proceedings will usually be brought by the Crown Prosecution Service, which is the CPS, in the name of the Crown, and will be heard in a magistrate's court or a Crown court. Private prosecutions are also pursued by parties who have a specific interest in a case, such as the RSPCA or Royal Mail. Criminal law examples. So we've got examples of offences that breach criminal law. While not an exhaustive list, include things like criminal damage, sexual assault, murder, fraud, money laundering, drug dealing. These are some of the examples, okay? Not all the examples. If someone is convicted, the offender will receive the penalty laid out in the relevant legislation and sentencing guidelines, usually in the form of fines, prison sentence, or community orders. What does community orders mean?
Potentially to service as a social worker for in public area.
So you would have to do a number of hours in the community. For example, you could be, cleaning the walls or cleaning a building, and that's your community work that you need to do, but you have to do a number of hours a week. In order to be found guilty of a criminal offence, the person must have proven guilty beyond reasonable doubt. They're considered to be innocent unless proven guilty. So we're looking at the justice system in the UK. The justice system is one of the three branches of the state. The other two branches are the executive or the government and the legislature, which is the House of Parliaments. In the most democracies, these three branches of the state are separate from each other. They have roles and functions that are defined within written constitutions, preventing the concentration of power in one branch and enabling each branch to serve as a check on the other two branches. This is known as separation of powers. Why is there a need to have this separation of powers? Why do you think it's important to have a separation of powers between the different branches of the state?
So that one branch can get corrupted and potentially dictate everything.
Excellent. Dictatorship. In some countries, do you have dictatorship?
Yeah.
Give me examples of some countries that may fall within this dictatorship.
North Korea is a direct dictatorship. China is a bit on the communism side, I
Yeah.
guess. These two are the ones.
What about Asian countries like Pakistan and things?
Yeah, small
Yeah.
regions are affected now.
Yes, more of it is affected now because of what's happened in the country, but because of having no separation of powers, it causes a
Yeah,
dictatorship. And what happens? What does one branch think they are more powerful than other branches?
they try to dictate everything,
Yes,
whatever they want
yeah.
in their
They try
preference.
to, they try to dictate everything. They don't try to have a defined, area of work that one branch does. It's good when they work together. It's just when they start working separately that they feel like they're in power. And that's why it is really important to have separation of powers, but also there should be checks and balances in place where there's no abuse of power. Because like you said, abuse of power causes dictatorship. And that's where one country will feel more powerful than the other. And that's happened in a lot of the Asia states, the African states, where, you know,
Somalia.
Sorry?
Somalia, the country in
Oh,
Africa, same.
yeah. And what's been happening there? Where is there no separation of powers there?
Yeah, there is no separation of power, and small factions have been created
Yeah.
which
And
govern.
does that help the country?
No, they
No.
have been like an anti-hero for the time being, but in the long term, their country has been affected negatively.
Yeah. And it impacts on not just the country, it impacts on the people in the country, doesn't it?
Yes, yes.
Yeah. So it's very good to have a separation of powers, but also work together and have checks and balances so you don't have any abuse of power. The role of government in lawmaking and the justice system. So how does the government make laws in the UK? So we have an Act of Parliament. It creates a new law or changes to an existing law. Then you have an Act is a bill that has been approved by both the House of Commons and House of Lords, and then given royal assent by the monarch or the king. Taken together, Acts of Parliament make up what is known as statute law in the UK. So there is a procedure, a passage of bills that is followed. So you have a first reading, second reading, third reading, committee stage, reporting stage, where amendments are made. Everyone approves it, both in the House of Commons, House of Lords, and then a bill becomes an Act of Parliament. Okay, that's once that's been signed by and given royal assent by the king, then that will become an Act of Parliament. Okay, and that only becomes law once it's given royal assent. So it could go back and forth for any amendments that they need to make, and make sure that the law is correct, and all this goes through Parliament. The organisation of the judiciary. So the organisational structure is premised on the following: a Constitutional Reform Act 2005 and the concordant set out in the responsibilities of the Lord Chief Justice as a head of the judiciary of England and Wales, and as a president of the courts of England and Wales in respect of the judiciary. And what I'm going to do now is I'm going to put you on a video about the judiciary. Okay, so you're able to understand the judicial system in the UK.
Okay.
So the video we've just watched was looking at the role of the judiciary in the UK, and it was Lady Hale. What did you think of that video?
It was a nice video with the breakdown of the role of each of the parties involved, the parliament, the monarchy, and everything.
Yeah. And it also identified that everyone should be equal, didn't it? That she said that, you know, there should be a rule of law, which is equality. And
Yeah,
there should be, everyone should be, no one is above the law. Everyone should be treated equally. What do you think
yes.
that means?
Basically to respect the rights of everybody, every citizen,
Yeah.
as well as taking into account the
Yeah,
remnants of the influence of monarchy.
yeah, that's so important, to treat everyone equally, and no one is above the law dependent on, you know, their rank or their status. They shouldn't be above the law. Everyone should be equal. And what she said was that there should be no secret laws. What do you think she meant by that?
Basically, that every law that is being governed should be publicly available to
Yes.
everyone.
Excellent. So every law that has been introduced through Parliament and every bill that's become a law should be available to the public. You know, there should be no secret laws around. She talked at the area of judicial review, how people can take an organization to judicial review if there's been any sort of discrimination or anything. So their role is quite wide, isn't it?
Yeah.
And she was the only female judge, Lady Hale. But there is another one now that's joined. And there's more men than there are women within the judiciary.
Okay.
But it identifies that there's a need for the judiciary, isn't there, in lawmaking, in the justice system. You know, we in the Supreme Court, there's a need for that. And that video is, the link to that video is just there if you need to watch it in your own time as well. So what we've done now, we've finished this session on learning outcome 1, which is to explain the nature of the legal system. We looked at the legal system, we looked at the purpose of law, the evolution of law, so how it was developed over history. We also looked at legislation, directives, case law, and primary and secondary legislation, divisions and sources of law, the legal system, so the hierarchy of courts, and the difference between criminal and civil law, and also government in lawmaking, the justice system, the organization of the judiciary. And the link to the video is just there for you to have a look at. Some of the references are just there that we've used for today's session. And also, when it comes to any sort of plenary or anything, any inquiries you've got in regards to any sort of a session that you've had, these are all recorded and these will all be put on Moodle. And you need to make sure that, you know, if there's any additional sources, they will be put on Moodle as well. Any inquiries that you've got, you need to email learnerworks@UK submission of assignments at learnerworks@ukvarsity.co.uk. And the assignment submission is 2 weeks after the completion of the unit. So your completion of the unit is in 3 weeks, and then after that is the submission of the assignment. Have you got any questions before we finish off this session?
No, not from my side.
Ishika?
No, ma'am.
Okay, so thank you, and thank you for your patience, and thank you for attending today. And I will see you in tomorrow's session at 11 o'clock for learning outcome 2.
Okay.
Is that
Alright.
okay?
Yeah.
Yeah.
Okay. Have a nice day, everyone, and I will see you tomorrow. Thank you.
Thank you.
Thank you. Are you okay, Shika?